I am Richard Sierra. I represent Javier Oyola, who was the defendant below. He's the appellant in this action. Mr. Oyola appeals a decision of the circuit court denying his motion to vacate a default final judgment that we contend was a void judgment and should be vacated under Rule 1.540B. We ask the court to reverse that decision, vacating the judgment, allowing Mr. Oyola to proceed in the action, a partition action. The facts of this case are not terribly complicated. Mr. Oyola and Margie Solis were former boyfriend and girlfriend. They lived together in Ohio. They share a child together. They owned a home jointly in Polk County, Florida. A dispute arose between them in March of 2019. A domestic violence accusation was made against Mr. Oyola. He was arrested pursuant to that charge, a charge that ultimately would be dismissed. But while he was in jail on that charge, he was served with the summons and complaint underlying this instant action. Mr. Oyola doesn't read English, did not respond to the complaint, and a default was ultimately entered against him.
Counsel, we're familiar with the facts of the case. I want to ask you, so as far as notice goes, so your client received notice of the lawsuit while in jail, but he was served with process, correct, with the lawsuit?
We have no basis to dispute that claim.
Okay, and then he was also served with the notice of hearing when there was he served with notice of the motion for the clerk's default?
It reflects it was mailed to his home address.
Okay, and it is his home address, the address in Heat
It's
City?
his mother's address.
And he was living there.
Yeah.
Okay, so he was served with notice of the clerk's default. He was served, I didn't see in the record that he was served with notice of the motion for the final judgment, but he was served with notice for the hearing, correct?
I believe so. We haven't challenged the notice issue, Your Honor.
Okay.
They reflect that. I had conversations with my client. He had no recollection or knowledge. Our position is the judgment was void,
Okay,
regardless
so it
of the
goes
notice issue.
Okay, so a partition action was filed and void because of subject matter jurisdiction? That's
Yes,
just
Your
sole
Honor. The relief granted was not requested in the pleadings. In the complaint that was served upon him, the party, the Ms. Solis, asked the court to sell the property, to do what a partition does. A partition divides co-tenants' interests in the real property.
And agreed to the relief.
Excuse me.
He just showed up to the final hearing he was noticed for, and he could agree to the relief that the file for us. In other words, try to find consent.
Sure.
Outside of the pleadings, would we have had a basis to appeal?
No. If it was tried by consent, if the issue was presented to the court that his interest should be turned over, and that issue was tried by consent, and that's what happened. This was a taking, Your Honor. This was
struggle with the idea that somebody who doesn't show up and just ignores their right to advance any sort of defense would then somehow be in a better position than somebody who showed up at the sad time.
well, because the argument would be that the issue was tried by consent. He sat there, he didn't object to the request for a taking, so that's a consent. Mr. Oyola, the only thing you consent to with a default judgment is you acquiesce to the relief that's requested in the pleadings. If a man is served with a credit card lawsuit and he looks at it and he says, yeah, I owe the money, and he doesn't dispute it, he shouldn't be penalized because suddenly the credit card company gets aggressive when a default's entered and asks for more than was asked for in the original complaint. So
did the original complaint serve that the property?
It did, but it attached a copy of the deed. The deed, of course, reflected both were co-tenants, and in fact, it alleged in it that they were tenants in common. It alleged they had a right to possession, and it asked that the property be sold, and that from Mr. Oyola's proceeds, that the fees and costs be paid, intimating they understood that he had an interest and was supposed to receive proceeds from this sale. So, what ultimately transpired, the final judgment simply awarding the interest to Ms. Solis was not something he acquiesced to, something he had no notice of. We believe it was a fundamental violation of due process because he had no notice that they were going to try and take his interest, and he had no opportunity to defend that claim.
Why was your client's, I guess it would be a pleading defense, there's an issue with the pleading. Why was that not waived by not appearing, not filing anything? And I'm thinking of the Bank of New York Mellon versus Condominium Association of La Mer Estates, Inc. from the Florida Supreme Court, which says that when defenses as to the pleadings are not raised, that they are waived.
Right. I don't think this was there was the pleadings sought a partition. It invoked Chapter 64.
But she also said she had 100% interest,
Yes,
which may or may not have conflicted with the deed that was attached.
it clearly conflicted with the deed
Is
that
that a
had.
pleading deficiency that was waived?
Correct, Your Honor. That is a pleading deficiency, but in conjunction with that pleading deficiency is the fact that the relief sought was different from that awarded. There's no reasonable, I don't think it's fair to believe that Mr. Oyola could read that complaint and believe he's going to lose his interest in the home. If he took that to an attorney might advise him, well, she wants to sell your home and split the money. And he could reasonably say, well, I don't, and the attorney would probably advise him. She has a legal right to do that.
She's alleging that she has 100% interest in this property. That might be the problem.
Correct, but in a partition action, the way partitions work, and there's plenty of case laws setting that forth. I believe I've cited some of it. It's a two-step procedure. First, there's a determination of the interest and a sale of the property. And then if anybody wants to claim that they get more than that, if they want to make a claim for special equity, the court then is supposed to take possession of the proceeds and then hear that out. If somebody wants to claim, I paid all the mortgage payments or I paid all the taxes, I should get additional credit. And that's the way a partition action proceeds. What transpired here was simply a taking of his interest for which he had no reason to believe would transpire.
Wasn't your client's obligation to go to the hearing? Because the case law, if I'm hearing you correctly, you're not really arguing that.
No, that's not true. No, Your Honor. I think a subject matter jurisdiction is not simply the jurisdiction the court has to enter that type of order. It has to be properly invoked by the court. It has to be properly teed up. A circuit court can do a lot of things, but the relief granted has to be what's asked for in the pleadings. They could issue a money judgment, they could issue an injunction. Simply because they have the power to do it doesn't mean that subject matter jurisdiction has been invoked. It has to be properly teed up in the pleadings. In this case, the only thing that was being invoked, it was title and action for partition. It invoked Chapter 64.
I understand that, but in response to the question, you said that if the client had a fear, then an issue with the wrongful extension of the non-scope of the pleading, the matter could have been filed by consent.
Correct, Your Honor.
Well, if it's subject matter jurisdiction, party can never be with subject matter jurisdiction. So that issue, how can that ever be subject matter jurisdiction?
The issue, the description, what constitutes subject matter jurisdiction is, you're right, they can't consent to, he can't go into county court, agree to a judgment exceeding county court jurisdiction, okay? But a circuit court can grant a variety of remedies, including money judgments, equitable relief, etc. To the extent the court has that ability, you can consent to that if the issue is tried. If you try a matter by consent and matters that are submitted to the court and not objected are considered matters that are tried by consent, you can. So the concept of subject matter jurisdiction constitutes two levels. One is what the court in theory has a possibility of doing, the types of remedies that it can fashion. And then on the second level, the extent to which a party has invoked those remedies, and it's a fundamental due process issue, provided notice and an opportunity to be heard.
An opportunity.
Correct.
You don't avail yourself of opportunity. That way.
No. All you,
What case you, right, where court found the judgment to be void, where the judgment, I read your case.
Correct, Your Honor.
I found several where it appears that the relief was awarded the tax part that after the default was completed, then an ex parte submission was made to the court without notice the opportunity to advise the party in default, and then the judgment was in. As opposed to being cited in the Supreme Court, with the Boston Act, where there was an opportunity to serve, there was notice of the hearing, and the party default chooses for whatever strategic reason or other reason they decided, they don't show up. And so, unanimously, of course, the court said there was an opportunity that the default and party chose not to avail. It may have been voidable because they did see cases where the party objected to the request for relief beyond the scope of the proceeding, not that they weren't on it, and then on the record, that was found to be problem work. But that meant the party didn't file a hearing.
Well, Your Honor, I think it'd be a strange rule, and I'm sorry I'm unfamiliar with the case that Judge Wozniak, I don't think it's one of the ones cited in the briefing. But it would be a strange rule that if a party defaults, that you can get whatever relief the judge is willing to give you. The cases I did cite.
I think I'm saying is that there are challenges. First round question. The notice of that last hearing that she received at his mother's house is problematic based on that. So the cases that are in the brief are situations where that didn't happen. And I think that maybe your argument is a little bit better in terms of void if you just have service in instead. But you have this additional fact that I think is relevant for the client, which is that he was noticed that he just chose to go.
Well, we don't, that's not established as a fact. We simply just don't know. Unfortunately, we can't challenge. It shows it was mailed. No, Your Honor, what's being challenged at the judgment, the underlying judgment was void. So when she made a finding, that was a finding that was made in a non-evidentiary hearing. It's undisputed that was a non-evidentiary hearing.
Where do we look to, if we see it your way, where do we look to how something is void? We have to go back. So for example, does holding in your favor support the proposition that 20 years after any final judgment is entered, you can go back and look at the wherefore clause of any particular complaint and say, oh, you didn't ask for attorney's fees, for example, and you got attorney's fees, so therefore it's void. Or do we look to the character of the cause of action that's being pled? Oh, you sought summary eviction, but you got a monetary eviction. How do we figure out if this rule is going to be in place, whether something is void?
Well, I think it is a rule that you only acquiesce to the relief that's being asked for when you default.
So that's the wherefore clause of the complaint.
I think you look at the entire pleadings. I mean, I think you look in this. I mean, in this particular complaint, it was an action for partition invoking Florida Chapter 64. So you would look at what constitutes a partition action. And what took place was not a partition action. In the end, no cases are presented to this court. In the annals of Florida jurisprudence, I've never seen a partition action where a court simply takes a party's interest in the property that's established by deed and simply transfers it to the other party. That's not what's done in partition. Nobody's arguing that's permissible or lawful in a partition action. And yes, the wherefore clause asks for a sale of the home and a division of the proceeds. So I don't think the court can look at this and reasonably believe Mr. Oyola should know or should realize that if he doesn't respond, he's going to lose his interest in the home. It was an action to sell the home and divide the interest, and that's what a partition action is. So I would argue that you look at the entirety. Your Honor, the cases I cited, they clearly state that when you default, you admit the well-pled allegations and acquiesce only to the relief that's sought in the pleading. There was no request to take his interest and just from him by Ms. Solis. That was only something that was done after a default. Oh, I'm sorry. No, Your Honor, that's fine. I'll say. Thank you.
May it please the court, Eric Studeman for the appellate. Your Honor, in hindsight, could the initial pleading in this case have been a little bit more clear? Absolutely, it could have. But the reality is this appeal is regarding a motion to vacate a final judgment that was filed 2.5 years after the judgment was entered. And so under Rule 1.540B, or I'm sorry, D actually, the only way that they're going to be able to have that judgment set aside is if the judgment is in fact void. And so that's the real question here. Is this judgment void or is it arguably voidable? And I think they
start by kind of asking how walk into the law school class with a sheet for, and I say, I'm going to partition this case among the members of this particular class. And then I hand it to the professor. Have I partitioned the case?
hand it to the professor and leave.
Or I hand it to the gunner in the first row?
No, but in response to that, I think if you walked in and said, Professor, I'd like you to decide who gets what of this cake, and he decided to keep it, I think that absolutely that he would have determined the interest in it. And if you look to the actual
So
statute,
64 effectively, can I read it completely identically to apply a title action?
completely identical, no, but if you look at Florida statute 64.041, it states that a partition complaint shall allege, according to the best knowledge and belief of the plaintiff, the quantity held and such other matters, if any, as are necessary to enable the court to adjudicate the rights and interests of the party. And so if you look to the complaint in this case, the appellee alleged that she had a 100% interest in the property. She alleged several other factors that would entitle to her to more than an equal share. And then in the wherefore clause, she didn't just ask for the sale of property. She was asking for relief in the alternative. She pled, wherefore the plaintiff requests a judgment determining the rights and interests of the party. So here she pled that she had 100% interest. She set forth allegations as to why, and then she asked the court to determine those interests. Ultimately, a default was entered, but mind you, this isn't a case where there was just a default and the judge signed off on a judgment. The judge set a hearing and held an evidentiary hearing. There's evidence in the record substantiating the judgment, including a sworn affidavit by the appellee indicating that she had paid for the proceeds with a disability settlement. There's a wire transfer in the record showing that the funds came solely from her bank account. There are receipts in the record that she's the one that made all the improvements to the property, plus her testimony, which we don't have the benefit of because there is no transcript. So this isn't a.
I looked at your case and I don't recall being paid with facts like we have here. But I understand what your client alleged. But are you aware in the side case, you know, the book that or something recently perhaps, where the plaintiff files for partition, alleges that one party has a 100% interest in the property. The judge determined that a party has a 100% interest. And then the remedy is, you're asking us to say that the remedy in that situation could be, instead of selling the property and giving 100% of the proceeds that was generated to your client, you're saying the judge has the authority, well, we'll just skip that step and we'll just give you the property in lieu of 100% of the fund. You have a case that would actually did that.
I've never seen a case where the judge did that, but going back to statute 64.041, it clearly indicates that you're to allege the quantity and other matters as necessary to adjudicate the rights and interests. It doesn't say they're gonna cut it in half and sell it immediately. That's not what it says. And so again, could this have possibly been pled with a third count, a quiet title in the alternative? Sure. But if you look at statute 64.041, it clearly says to allege the quantity held and other matters to adjudicate the rights and interests. And that's what the judge did.
If you look at the rest of the chapter, though, in terms of talking about what happens upon a award of partition, it usually looks like it takes 2 forms. You know, you can certainly partition off the apartment in the backyard. But if you've got one thing that can't be divided, isn't the typical way to do this? And you've got a whole statute, sub-statute about commissioners and sale, that you would effectively have the commissioners sell the property and award the parties proceeds commensurate to their interests.
If the court found that one of the parties didn't have an interest, I don't see why they would have to get to that step. Of course, if you had even a 1% interest, then of course it would have needed to go that way, but that's not what happened.
That's, you know, there's a typical Canada construction that talks about the expression of one thing with the exclusion of another. In the context of the statute, is there anything that suggests that you can just skip that step of sale and just give it to one person?
I think going back to the section that I've cited,
So basically,
64.41.
the judgment section itself is all we got.
Well, it's the complaint section. I mean, why would you allege the quantity that you've held and ask the court to adjudicate the rights and interests if
Maybe
you
could
knew the
say,
court
I've
was going
got
to split it?
0%. Maybe you could say, because I've got 0% and the other person has 100%, it'd be a motion to dismiss saying, you know, partition is appropriate.
I think that's certainly a judicial issue, but I don't think it's the issue that's really before the court here. In fact, in the appellant's brief, they cited a case, about 3 pages of it, actually. It was the case of Lovett v. Lovett, dating all the way back to 1927. And there's actually an excerpt in their citation in their brief that was spot on in support of the appellate's position. It reads, the pleading bringing the matter before the court not necessarily be sufficient in law to withstand the test of a demur, but as a general rule, it must state at least inferentially each material fact necessary to warrant the court to deliberate thereon and grant the relief accorded, which must usually be the relief prayed for, or at least not foreign thereto. Though as to the later, the form of relief when different from that asked, the judgment or degree may be merely voidable, but not void. And I think that's the issue we have here is, was our complaint possibly incorrect? Maybe, but that's not the issue here. This motion to set aside that judgment was brought 2.5 years after it was entered. There's a presumption of finality, and the only way around that would be if the judgment's void. And pursuant to that Lovett case, it's not. Anyone who looks at that complaint can see, as I think the court's already pointed out, the appellee sought a 100% interest and asked the court to adjudicate the party's interests. Is that spot on exactly how it should be? Probably not. Does it certainly give somebody notice about what they're asking for? Absolutely. I don't know how anyone could read, she's claiming 100% interest and go, oh, that's a problem. I own part of it and not do anything. This isn't a void judgment. It's at best a voidable judgment. I cited another case. It's the U.S. Bank National Association v. Anthony Irish. A lot more recent. It's not 100 years old. It's 2016 out of the 5th DCA. And that case clearly explains that a procedural defect relating to the court's power over a specific dispute is not a defect in the court's subject matter jurisdiction. And so if we're going to just a defect here in the pleadings, this is a procedural issue. And it needed to be challenged within a year of the judgment. That's not what happened here. This is 2.5 years later. The court would have to find that this was a void judgment in order to reverse and remand this back to the court. But respectfully, in my opinion, I don't see how that could possibly happen. Thank you.
Brief rebuttal, Your Honor. The complaint attached the deed. The deed showed that my client had a interest in the property and was a tenant in common. That prevails over any allegation that's brought in there. I don't think it's fair that there's no reason for him to think the court would ignore that. And what transpired was not a partition. This wasn't he cites to the statute saying Sure. I didn't want to bore you with reading, but I mean, I'll take the quote the reason I cited it and what I believe is the Supreme Court's decision. It says, and I'm taking context. It says there must be a right in dispute between two or more parties, and this is discussing jurisdiction. So I'll go back to it. It says jurisdiction is of the subject matter is a power to deal with a general abstract question, to hear the particular facts in any case relating to this question and determine whether or not they are sufficient to invoke the exercise of that power. But before this potential jurisdiction of the subject matter, this power to hear and determine can be exercised, it must be lawfully invoked and called into action. The parties in the subject matter of the particular case must be brought before the court in such a way that it acquires a jurisdiction and power to act. There must be a right in dispute between two or more parties. A proceeding commenced under the proper rules of law. Process must be served on the opposite party or parties in order they may have an opportunity to be heard, or the property, if that be the subject matter of the action, must be within such jurisdiction. And the owner or person having the right to claim it or to be heard must be notified as required by law of the pendency of the proceeding. The jurisdiction and the power of a court remain at rest until called into action by some suitor. It cannot by its own action institute a proceeding sua sponte. The action of a court must be called into exercise by pleading and process prescribed or recognized by law, procured or obtained by some suitor by filing a declaration, complaint, petition, cross bill, or in some form requesting the exercise of the power of the court. If a court should render a judgment in a case where it had jurisdiction of the parties upon a matter entirely outside of the issues made, it would of necessity be arbitrary and unjust as being outside the jurisdiction of the subject matter of the particular case, and such judgment would be void and would not withstand a collateral attack, for upon such matter a presumption would arise that the parties had had no opportunity to be heard. And that's what I'm arguing, Judge. These pleadings. Yes, but it's addressing the issue of subject matter jurisdiction. Subject matter jurisdiction is not simply the power of the court to do something, but it's also the power to do it after having been properly invoked by a process that involves notice, service, and proper pleadings that put you on notice.
When you say notice and service, saying, well, that's all under the umbrella of subject matter jurisdiction. How can that be right? Because if you're not served with a lawsuit and you show up for trial and a judgment is entered against the defendant shows up without being served, that judgment void.
No, of course not. You're saying, but I mean, if you're there, you obtain notice at the trial. I mean, you can't say I didn't have notice if you're not there.
But do you waive the ability? If you weren't served with the process, you read it. You read about it on. You saw it on
Sure.
TV.
Sure.
You show up.
And you show up, then you had notice. I mean, you certainly obtained notice when you walked in the courtroom and they explained to you what's going on. But you don't have notice that somebody's trying to take your interest in property when they serve you with a complaint for partition. And that's the thing. So he wouldn't have, if the judgment.
Part in love it where it says, if the form of relief awarded is different from the relief requested, which is exactly what happened, it may be voidable, but not void.
It may be voidable. That's true. It may, yes. It depends on what exactly transpires. I mean, that's a very broad that a whole lot of things can happen in the course of granting relief that's not requested. But if the party had no opportunity, I'm over time, Your Honor.
Thank you.
But thank you, Your Honor.
Appreciate this. submission. Part of this.
I apologize. I've never done the oral argument for in person or weeks.
Yes.
It used to be.